Hi, my name is Jim Selbach. For over 32 years, I ran a high-volume consumer bankruptcy practice in Central New York. Since 2006, I've developed a satellite bankruptcy practice involving automatic stay and discharge injunction violations. And I'd like to just take a couple of minutes of your time, I know you're busy, to show you how my system and my network can enhance your bankruptcy practice, can enhance the services you're providing to your clients, and provide passive income to you. Right now, we have 15 law firms that regularly refer bankruptcy stay violations and discharge injunction violations to our office here in Central New York. And here's how my system works. You refer all of your potential stay violation and discharge injunction violations to my office. Now, I can tell you from running a high volume practice and from doing this that you have many more violations in your office than you might imagine. Your clients are getting dunning letters and income executions and bills, calls for demands for payment, more than you suspect. A lot of time because your clients aren't educated, they don't even know what to do. They sometimes don't even tell the bankruptcy attorney what's going on. We have a system for that. We have educational materials so that your client knows what to do when they get a statement, a bill, a phone call. And you'll find that you'll be surprised at how many of these cases you have. Here's how it works. It's an easy handoff. Your staff doesn't do anything. They just simply refer the matter to us. They don't even if they suspect it's a violation, that's what we want to do. We'll check it. Okay, we don't want your staff to do anything except refer it. We have a website where there's a space there that you can refer the matter to us. You can email it to my staff. You can fax it. We don't care, but it's an easy handoff. We do all the work. We determine if there's a violation. We determine what must be done. We file the motion. Your staff does nothing except refer it. We become special counsel. You remain bankruptcy counsel. You see this a lot in Chapter 11s, where there'll be special counsel for certain special things that are happening in the case. It's no different here, whether it's a 7 or a 13. You remain the bankruptcy attorney. For all other matters except the motion, you're involved, you answer the questions, you are in charge of that. For the specific reason of the motion, we handle that. We'll answer your client's questions, we take care of that matter. We investigate the claim. We just need the debtor's name, the bankruptcy case number, the offending documents if you have any. We go on PACER. We make sure the creditor was listed. We determine whether there's a violation. We speak with your client. We introduce ourselves, we explain how this works, we understand what we're going to do for them, we answer their questions, and of course, many times we have to speak with your client to determine whether there's a violation to begin with. It's a contingency fee. This is a fee shifting statute, so the offending creditor has to pay our fees. So your client will never owe us any money no matter what. Even in the unlikely event that we withdraw the motion, which almost never happens, your client will never owe us any money. And that's an important thing that we discuss with them at the first time that we call them, because obviously they're concerned. Yeah, they want somebody to do something about it, but the last thing they need is more fees. Now, two things happen once we determine there's a violation, and we determine that there's been a retainer agreement signed by the client. We either file the motion, or in many cases, or maybe most cases, we have contacts with debt collectors, debt buyers, law firms that do collection work, so that when we have a contact, we draft the motion before filing it, we email it to our contact, and because they've worked with us many times, they know we're not bluffing, we're serious about this, we get these things settled many times without filing any kind of a motion. If we do file a motion, we have it returnable far enough in advance that before it ever gets on the calendar, we've got the thing settled. Most of these cases are settled as you would suspect. We pay your client. Once this is settled, Your client gets a portion of the proceeds. We distribute the money to you, your client, and to our office. We share 25% of the fee with you. We have a form you fill out to make sure that we're compliant with the bankruptcy code and with the canon of ethics, but you don't have to do any work. You just have to sign that form. So what's the benefits of this? Well, the first benefit is that it relieves your staff of a lot of work. I remember what it was like. My staff was there to file bankruptcy petitions. So they have a stack of files. They need to get the petition and schedules done, and now they got to drop it. They got to call people. You won't have to do that anymore. It takes 2 minutes to send it to us. You're done. We'll take care of it from there. Makes your clients very happy. Somebody is actually doing something about this violation, and they're getting money, which they never expected to begin with. This reflects very well on your office. They're very happy with your services. You took care of the violation, and you gave them a check that they never knew they were going to get to begin with. It's passive income for you. You have a stream of income right now in your office that's just not tapped. We will tap that. And so you'll get regular income. I send checks out to my network attorneys all the time. There's checks going out the door every single week. So we'd like to make you part of that network as well. If you'd like to talk to me about this in more detail, call me here in my office in Syracuse at the number you see on the screen, or you can shoot me an email and I'd be happy to talk to you. Thanks for you're taking the time to listen to me.